Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the synopsis of EWS judgment, Economically Weaker Sections judgment. Yesterday, when I asked some of the students to tell the case law, of course, everybody is saying that it is only EWS case. But you must cite the case law. What is that case law? Don't forget it. So that's why I am making it as a video. So in the case of nhit Abhigyan versus Union of India, in writ petition, civil writ petition number 55 by 2019 on 7/11/2022, the Constitution bench, that is 5 judges bench, the majority ruled that reservation solely based on the so-called economic criteria does not violate the doctrine of basic structure. This is the Supreme Court verdict on the EWS quota. Simply to say, you have to know who are the 5 judges, including the Chief Justice, erstwhile Chief Justice of India, Sri Uday Umesh Ladit, Ravindra Bhatt. Both of them dissented. Whereas, so Justice J.B. Pardhiwala, Justice Dinesh Maheshwari, and Madam Bela Trivedi, these 3 people, majority opinion, they have supported the EWS quota. So definitely, now even though 103 amendment is not directly touched by the Supreme Court, but it goes to say that 103 amendment is 100% correct. They have approved the 103 amendment, whatever it is. So the Supreme Court stated that reservations on economic basis, they do not destroy the basic structure doctrine, which is a very famous doctrine propounded firstly in the case of His Holiness Sadhguru, that is Keshavananda Bharati case. Keshavananda Bharati versus State of Kerala 1973 case. Right. So, the petitioners on behalf of nhit Abhigyan, they argued that till now reservation is based on socially and second development, socially and educationally backward classes. They have to get the reservations. You know that reservation, Article 14 says everybody should be equal before the law. Article 15 says there should be no discrimination, everybody should be treated equally. But this is protective discrimination. I already told you what is protective. So, in order to maintain the balance between the haves and have-nots, of course, if it is economic theory, we can say like that. So, in order to strike a balance, the government wants to uplift the so-called backward people like SC, ST. So, actually backward classes means SC, ST. That's why previously in Mandal Commission case, so they call as OBC, other backward classes. So, the wording is very, very important. So, that's why they have used the word other backward classes. So, previously reservations are based on social and educational backwardness and not economic disadvantage. So actually, when we appeared before the Manjunath committee in regard to the Kapu reservation, there they have clearly stated that you can't say economic development, economic backwardness, because the government is contemplating so many welfare measures like Mahatma Gandhi National Rural Employment Scheme, food security scheme, Anganwadi scheme. These are all the economic measures. So don't say like that, they have told. I am clear in that aspect. So the reservations were solely based on educational and the so-called social backwardness. But now the government has proposed through 103 amendment economic backwardness. This should not be there. This is the argument of the petitioners. But the judgment by Honorable Dinesh Maheshwari, that is in support of the so-called reservation on EFS, he stated that he emphasized the realities of the socio-economic order because he based on the UN General Assembly resolution dated 25/9/2015, that is the distinction between the haves and have-nots should be nullified. Alage, they have also proposed to set the eradication of the poverty among the nations. So, even according to Justice Dinesh Maheshwari, he noted that the Honorable Supreme Court of India, in its previous judgments on social justice, has been guided by the US jurisprudence. You may be knowing US normally their school is called as the realistic school. Homes, the realistic school. That means place based on the realistic, but not on the natural school or a philosophical school. Our schools are a philosophical school or the so-called historical school. No, they want to depend on the realistic school. So reality, yes, definitely poverty is still there. In India, the records say that 20% of the people are still below poverty line. So please remember, any civilized jurisdiction, they should not distinguish, or they have to make both haves and have-nots equal. So therefore, economic weakness or economic EWS can be taken into consideration. So he has cited the case laws. Already told you, Keshavananda Bharati. Second is MR Balaji versus State of Mysore, and R Chitralkha versus State of Mysore also they have discussed. Then ultimately, the court highlighted Indira Sawhney judgment. You know, Indira Sawhney judgment clearly stated that whatever may be the reservation, they should not exceed 50%. But here, see, the majority, they stated that the Indira Sawhney judgment of 50% reservation can be breached in exceptional circumstances. Always the saving clause will be there. You know. So they can be breached in extraordinary circumstances. So that is what Article 15 Clause 4 and Article 16 Clause 5 say. Now coming to the point of dissent. So U. Lalit and Ravindra Bhatt, they stated that definitely the amendment will create a scenario of compartmentalism. Now, right to equality, it gives right to reservation. It will be converted or it will be reduced into right to reservation. So ultimately, the Supreme Court majority, they agreed that reservation based on the economic basis is permissible. The reservation based on the economic principle is valid. So therefore, definitely the state, that means the government, can introduce such legislation. So this is according to the contemplation by the Constitution of India regarding the distributive justice. Distributive justice, yes, everybody should be distributed to remove the economic inequality. And Madam Triveni Bela M. Trivedi, she stated that treating the economically weaker section, EWS, is a reasonable classification. So they should also get the so-called adequate representation. To conclude, the majority opined that EWS is valid. So definitely the government will be very happy. Now, normally when we talk about the reservations, we used to say we don't belong to the class of reservations. For example, take a Brahmin. So he doesn't belong to any class of so-called reservations. Now, can you tell me any class which is not included in this reservation? So the reply will be no. Because any community people, if he is a weaker section man, that means if he is below some, that is, that 8 lakhs of yearly income, and also I think 5 acres of land, so that will be taken as a criteria. If you have the properties below that, definitely you will come under the category of EWS. So maybe any caste. That's a jocularly we can say all of us were brought into the so-called reservation spectrum. Tomorrow you can't say I don't belong to the reservation class. So if you are economically weaker, definitely you are also one of them. So anyway, Supreme Court upheld the validity of EWS reservation. We have to accept it. There is no other go. So there are some criticisms. We can discuss them later. Thank you.